thank you. Your Lordship asked about Group 7 and Nazir. Position, as we've now checked, is this, that permission to appeal was refused on the 10th of March 2020 by Lord Reed, Lord Carnwath and Lady Black on these grounds. Permission to appeal be refused because the applications do not raise an arguable point of law in the light of the recent case law in this court. The permission was sought by Mr. Landman and by notable being the LLP, to whom Mr. Landman's dishonesty had been attributed. My Lords, also just worth noting that Bilter and RBS, which I've referred to, the appeal in that is being heard this week, I understand, by the Court of Appeal, but aggregation is not in issue in the appeal. So, my Lord, going back to the pleadings, we had got as far as, I think, paragraph 175, if your Lordships could get back to that. I think it's page 232. And I'll take it very fast, my Lord. I should say, my Lord, that although I was slated to be from 2 until 4 o'clock, I don't anticipate that I will be all of that time. I think I'll probably be around an hour, depending on how quickly I make progress. So I'm conscious that your Lordships have looked at the pleadings, so I can take this really quite swiftly. As your Lordships will have seen, paragraphs 175 through to 177 posit an entirely hypothetical individual who did have all the knowledge on which SIB relies, but the point for present purposes is it is expressly SIB's case that no individual did have all of that knowledge, and as your Lordships have seen, it is in fact SIB's central complaint in the context of the Quinscare claim, where it's alleged that HSBC fell short of what a reasonable banker would have done in terms of gathering and collating information about SIB. But we say at the most basic level, there is a world of difference between an individual who has a body of knowledge, which let's assume for the purposes of this application raises in their mind a suspicion of fraud they deliberately decide, and a situation where there is no such individual, because as SIB vociferously complains, no one has joined the dots and put 2 and 2 together. And the question then becomes the question that Mr. Justice Nugee correctly asked. Why? That remains the correct question when you're dealing with a corporation. And unless you are able to assert, which my learned friend accepts he is not, that HSBC had a targeted suspicion that SIB's business was fraudulent based on knowledge actually held, and a deliberate decision was then taken not to look into it, or unless you are able to assert that HSBC recognised a risk that SIB was a fraudulent business and simply didn't care, which again is not to be found in the pleadings, you are not in the territory of dishonest assistance, you are squarely in the territory of negligence. We move on to paragraph 178. My Lord, that puts forward 3 bases on which it said HSBC is to be regarded as having the knowledge set out above. So these are, on any view, all dependent on the notion that you can in some way gather the knowledge of a whole disparate array of individuals and attribute that knowledge as a synthetic knowledge to the mind of HSBC, and we say that is squarely contrary to authority in every way that my learned friend seeks to put his case does in fact depend on aggregating knowledge in that prohibited way. In pleading in these terms, my learned friend correctly recognises that knowledge is inescapably a component in whether you can label conduct as dishonest, and we've been through the authorities in that respect. At one point yesterday, it seemed that Mr. Fenwick sought to resile from that analysis. Now, the first of the three ways in which the case is put in this paragraph is corporate recklessness. Let us just follow through in the pleadings to try to understand what is meant by that term. Can I take you, we'll come back to 178 and what follows, but let's divert by way of the defence and the reply. If we could go to the defence at page 308, and it's paragraph 107. We first take issue with SIBS claiming that it can't at present plead dishonesty against any individual, but if you go on past that to 107.2, we say, faced with that reality, SIB purports to rely on HSBC's alleged corporate recklessness. That contention's both novel and misconceived as a matter of law. SIB can't circumvent the need to prove dishonesty by that means. And then we go on to say that everything else is without prejudice to a strikeout. And then if your lordships go on at 107.3, we say, corporate recklessness is a misnomer. The matters relied upon would at most amount to no more than negligence, and negligently failing to identify facts that would have been, which would, if they had been identified, have indicated fraud, is not turning a blind eye, and you can't synthesise by aggregating. And then, and this is what I wanted your lordships to focus on in particular, at 107.4, furthermore, there's no basis to allege that HSBC set up and operated its policy systems and procedures not caring whether or not fraud was identified and detected. No individual, still less an individual who could be regarded as the directing mind and will of HSBC, is alleged to have had that state of mind. Indeed, the facts pleaded at, for example, paragraphs 151 to 153 of the particulars of claim, my lords, those are the paragraphs that set out in extensive detail all the systems and processes that HSBC in fact did have in place in order to observe anti-money laundering regulation and KYC requirements. We say all of that is inconsistent with there being any such state of mind on the part of those responsible for the management of HSBC, nor could generalised recklessness about KYC or AML policies, if as such were proved, be a basis for imputing to HSBC knowledge of SIB's specific circumstances and of the facts relied upon as indicative of the fraud on SIB, absent proof of deliberate disregard of those circumstances and facts. Now let's go on now to see how that was replied to, and the reference is page 360. There are two paragraphs in the reply that we need to look at, the first of which is paragraph 26. It's actually responding to a different paragraph in our defence, but the point is the same. It's not alleged that HSBC was reckless in relation to AML in the abstract. Rather, as is clear from the particulars of claim, it's alleged that HSBC was reckless in the institution and application of its own policies and procedures to SIB. So that's the nature, apparently, of the allegation. And then if we go on, my lords, at page 397, sorry, we probably need to pick it up just at the beginning on the previous page, 396, footer 396. Paragraph 89. Now this is the paragraph that responds to our paragraph 107. Denial that the plea is misconceived as a matter of law. So it goes on to say that it's consistent with public policy considerations of fraud prevention to aggregate the knowledge held by individuals, if and to the extent that such knowledge taken together is sufficient to amount to dishonesty or recklessness. I'll come back to that because we say this is a circular argument. And then at 107.4, they say in response to 107.4 at subparagraph 2, that is based on a mischaracterization of SIB's case, because SIB does not allege that HSBC operated its procedures, systems and policies not caring whether or not fraud was identified or detected. SIB's allegation is that HSBC's failure to institute and or apply proper policy systems and procedures was one element of HSBC's recklessness. So clear statement there as to what they're not alleging. One was left, frankly, somewhat puzzled as to what they are alleging. So there was some follow-up to that, my lords, which one can most conveniently pick up from core bundle R skeleton argument. It's page 60 of tab 5. Paragraph 42, towards the foot of that page, where we sum up our efforts to clarify quite what SIB was alleging. SIB had, prior to the hearing before Mr. Justice Nugee, clarified that it doesn't allege HSBC reckless in the abstract. That's paragraph 26. Doesn't allege that HSBC operated its procedures, etc., not caring whether or not fraud was identified or detected, paragraph 89.2 of the reply. And then we have our further endeavours to clarify this by way of correspondence. The correspondence itself, my lords, is in the supplemental bundle. The page reference is given here, but we can just summarise it from here. So SIB's solicitors told us that they do not allege, that SIB does not allege, that HSBC was generally dishonest, reckless as an institution in the way that it operated AML. And then in a subsequent letter, that SIB does not allege that the nature of HSBC's policies and procedures was such that even their perfect implementation would have been reckless. And in that same 19th January letter, that SIB does not allege that HSBC was reckless in the manner in which it applied or failed to apply its own policies and procedures in relation to other customers, but not SIB. So what we are left with is that the allegation is that HSBC was reckless specifically in how it applied its policies and procedures to SIB. No such allegation as was developed in oral submissions about some higher-ups who just in some very generalised way don't care about AML, something which, quite frankly, if that had been alleged before this court, the argument would have been different, and indeed before Mr. Justice Nugee, because that would have led to an argument about whether there was any reasonable prospect of making good such a case in the face of the array of policies that one had, and with not a shred of evidence, no fact pleaded, that would support such an allegation in the minds of any of the relevant people at the top. But that wasn't the case, expressly was not the case, that SIB was advancing. And therefore, that's not in way the argument. That's not the way the argument developed either before Mr. Justice Nugee or in terms of the skeleton arguments before this court. So, as I say, what one is left with in the pleaded case is the argument that specifically HSBC was reckless in how it applied its policies to SIB, and yet, my lords, it's not alleged. And Mr. Fenwick made this clear this morning, that any of the individuals who actually did manage SIB's accounts had the requisite dishonest state of mind. None of them recognised that there was a risk that SIB was being run as a fraudulent business and didn't care. So if we go back, my lords, to the particulars of claim, and paragraph 178, where we were before, which is page 235, the second basis advanced there for aggregating knowledge, and may I say, my lords, that the argument before Mr. Justice Nugee was to the effect that SIB needed to aggregate knowledge, and SIB relied upon some Commonwealth authority, which in the event wasn't developed in oral argument, and which did not, in fact, illustrate or did not provide authority for the point that in the Commonwealth you could aggregate, even though you can't do so here. So that was the kind of focus of the argument. But in a shape-shifting sort of a way, the argument for your lordships has become this quite different and unpleaded argument about these hypothetical high-ups who don't care despite all the policies that evidence the contrary. An argument that was expressly disavowed in what I've shown your lordships. Now, back on paragraph 178, the second basis for aggregating knowledge, the necessary knowledge for the first subjective stage, is aggregation as a freestanding plea. So by reference to the aggregated knowledge held by or conduct of the individuals within HSBC, there it's identified as a principle of aggregation, but the entire paragraph depends on the proposition that by one route or another you can attribute all of the knowledge above to HSBC. And one can deal with that shortly, because we've already referred to the cases that say you can't synthesize a guilty corporate mind out of innocent individual minds. Z and AZ was an attempt to do so in the context of contempt. And your lordships have seen that that is not the way in which dishonest assistance has been approached in any of the cases where it's been alleged against a corporation. And then the third basis, my lords, is turning a blind eye. But one has to analyse the pleading carefully to understand what it is that, in fact, HSBC is alleged to have turned a blind eye to. So the label that's applied is that HSBC turned a blind eye to whether SIB was being run dishonestly in the circumstances set out in the next three paragraphs. My lords, you are not obliged to accept the label that SIB chooses to apply to the pleaded case. You can interrogate that label and ask yourselves whether the circumstances set out in these three paragraphs, and indeed the remainder of the pleading on dishonest assistance, warrants the label that HSBC was turning a blind eye to whether SIB was being run dishonestly. Now, in that first sub-paragraph, you have nothing more than a pleading of negligence. The word ought is firmly and squarely the language of negligence, and that then ties in with paragraph 179, if we could glance forward for a moment to that, which is more of the same. If you run down the particulars, you see things like subparagraph 4, HSBC failed to apply necessary, reasonable or appropriate professional scepticism. Well, that's a concept lifted from auditing, completely inconsistent with the starting position in Quinn's care of trust and commercial relationships. It's simply a world away from HSBC turning a blind eye to suspicions of fraud. And then over the page, my lords, at subparagraphs 5 and 6, one concludes at 6 with the notion that HSBC was motivated by a desire to preserve the income derived from SIB. Now, that motivation is normal business behaviour, unless you are alleging that someone held a targeted suspicion of fraud and ensured SIB would not be appropriately scrutinised so that the income would continue. That allegation is nowhere to be found. So this, again, falls far short of a plea of blind eye knowledge or recklessness in the sense of dishonesty. By the time we get to paragraph 180, it is fair to say that this is being characterised as a reckless failure to institute or operate systems. But again, your lordships are entitled to interrogate the label reckless and ask yourselves what the content is that is being placed within that empty vessel, a term in itself equivocal, which may mean no more than gross negligence. And nothing here enables you to fill that empty vessel with dishonesty. There are two isolated instances pleaded in these particulars of particular individuals making statements in respect of KYC that are characterised as reckless, but SIB has always made clear that it expressly does not allege that either of those individuals had the requisite knowledge to be liable for dishonest assistance. So in all of this, your lordships have to ask yourself, as was said in Three Rivers, where is the pleaded fact that tilts the balance and makes a finding of dishonesty more likely than one of negligence? Applying the label reckless is not transformative if the proper ingredients just aren't there. So let us go back again to 178, paragraph 178, page 235. What else is there in these circumstances that are relied upon? We've dealt with one. What about two? Subparagraph 2 alleges the turning of a blind eye. But to what? Not, crucially, turning a blind eye to a suspicion which it's alleged has been harboured by anyone at HSBC, even someone who can't yet be identified. Far from it being turned so as to deliberately ignore a targeted suspicion about SIB, the supposed blind eye is turned to ignore what's alleged to be an ingrained culture at HSBC of failing to obtain, segregating or fragmenting knowledge. In other words, a culture of carelessness. We are not given even the broadest of clues as to who in the bank turned the putative blind eye, not necessarily names, but even at the level of areas of function and responsibility. Is it said to have been done by those with day-to-day management, by those who set the management of the accounts of SIB, or by those who set the policies, or those in the compliance function, or what? And that's not a point limited to identity, it's about exactly what this allegation is supposed to mean. And I've taken your lordships to how we got that clarified, and the clear statement as to what was not being alleged. So one's left, as I say, with the notion that those who managed the accounts hands-on were reckless as to the possibility that SIB was a fraud, but that allegation has no necessary content unless you are able to say they had the requisite knowledge and just pushed on in the face of the known risk. And SIB cannot and does not say that. So, as we say, this is not a valid plea of blind eye knowledge of SIB's fraud. It's a plea that HSBC failed to know and suspect what it should have and would have known and suspected if it had joined the dots. And it's a plea that a failure to join the dots was more widely endemic at HSBC and was something that HSBC hadn't tackled as it should have done. But crucially, nowhere is it alleged that HSBC didn't tackle this ingrained culture, because knowing XYZ facts about SIB, HSBC actually suspected fraud and decided not to inquire. The complaint is precisely that HSBC did not have that knowledge or suspicion. You see how it's put in terms of the Quinscare claim. And nor is it alleged that HSBC allowed the ingrained culture to continue unchecked as part of a deliberate decision not to find out whether its suspicions about SIB were correct. There's no allegation that that could be the purpose, and nor could there be, since it's not alleged anyone held such a suspicion. So we say, without any of that, this is not a proper plea of dishonesty. Again, if we go back to paragraph 178 now for the third subparagraph, and here we're on page 236. Now that doesn't add anything, because whether HSBC acted dishonestly by objective standards can only be addressed after you have identified whose subjective knowledge and actions are to be attributed to HSBC for that purpose. So this is a bootstraps argument as it stands. Paragraph 181, my lords, and now if we scroll forward, we have to get to page 241. Paragraph 181 rounds off SIB's pleading on this cause of action, and it starts thus: indicating that it is SIB's characterization of the facts that have been pleaded before this point. And it's a peroration elaborating at some length on the theme that HSBC had a dysfunctional structure. That, my lords, is a phrase lifted from the singularis case where dishonest assistance failed. It's alleged that this dysfunctional structure caused knowledge to be dissipated when it should have been accumulated, and there are various references to recklessness in subparagraphs 3 and 5, but still no pleading to the effect that HSBC actually knew enough to suspect fraud but turned a blind eye. And the word ought, which your lordships find in subparagraph 5, gives the game away. All of this is just a repleading of the negligence case with the addition of pejorative epithets. So, my lord, to sum up where we say that survey of the pleadings gets one to, and the reference for this, my lords, is paragraph 47 of our skeleton, tab 5, page 62. You couldn't get home against an individual by pleading, here are the facts you ought to have known but didn't, which cumulatively, had you known them and considered them together with such facts as you did know, would have given rise to a suspicion you did not have. You turned a blind eye to your own incompetence in collecting and collating facts, which is what the culture allegation is really saying. Therefore, you should be treated as knowing that which you did not know and suspecting that which you did not suspect. And we say that is exactly what SIB has done here. That pleading wouldn't work against an individual, and it doesn't work as against a corporation. To allow it to work against a corporation would, as I say, drive a coach and horses through the test as to dishonesty, which has been settled at the highest levels and applied in cases including in the Court of Appeal in Group 7, where a corporate entity was involved. So to do so, to allow a plea in those terms to amount to dishonesty against a corporate entity would be to fatally blur the bright line between honesty and dishonesty. Now, my lords, SIB submit, and the reference for this is paragraph 32 of their dishonesty skeleton, tab 3, page 23. Give your lordships a moment to get to that. They say that something went catastrophic. Sorry, it's not 32, it's 31, foot of page 23. Paragraph 31. Something went catastrophically wrong at HSBC to the extent that HSBC cannot have acted and failed to act as it did without having acted dishonestly for the purposes of a claim in dishonest assistance. My lords, res ipsa loquitur might get you to negligence, but it does not get you to dishonesty. The pleaded facts have to tip the balance, and they do not, on the pleadings you have before you, tip the balance and make a finding of dishonesty more likely than one of negligence. Something going catastrophically wrong in terms of systems and processes is unfortunately not a completely novel situation within a corporation, and Singularis and Daiwa illustrated just such a case. Cannot succeed in dishonest assistance, can only succeed by way of breach of the quinnscare duty, if at all. So, my lords, to sum up, in bringing a claim against a corporate entity, SIB necessarily has to confront the question of how to attribute a dishonest mind to HSBC. Mr. Fenwick can't skip over the subjective stage of the test and dart straight to the objective stage. And each of the ways that SIB puts its case in that regard to arrive at some form of constructive knowledge is flawed. My lords, going back to the first of those approaches, that is corporate recklessness, which your lordship saw referred to at paragraph 178. We've addressed that at paragraphs 57 to 58 of our skeleton, that's core tab 5, page 65. And the point I'd like to particularly highlight to your lordships is this, that SIB's argument in this respect is entirely circular. SIB relies on corporate recklessness as a justification for departing from the settled law that you can't aggregate innocent minds. And if we can just follow that through, one gets that at paragraph 53.5 of SIB's skeleton. I think it's page 34, if your lordships could go to that and have a look. So 53 subparagraph 5. In circumstances where the only reasons why knowledge which would be sufficient is fragmented, where the only reason for that is this ingrained culture. In SIB's case, there's no reason in law why the court should not treat HSBC as knowing what it would have known and ignore the fragmentation. In other words, it's being said that recklessness allows you then to aggregate. But then, at the same time, and your lordships saw this at paragraph 89.1 of SIB's reply, the reference, just to remind your lordships, but we don't need to turn it up again, core tab 16, page 396 to 7. What was there alleged is that SIB relies on aggregating knowledge so as to arrive at the conclusion that HSBC was reckless. So an entirely circular argument, the corporate recklessness argument, and not at all independent of aggregation. It fundamentally depends upon aggregation. And we say in any event, my lords, there's no such concept as corporate recklessness in any of the authorities on dishonest assistance, even though some of them have concerned corporate bodies. And that is for good reason. You need to plead dishonesty. Nothing less will do, and that includes as against a corporation. Recklessness isn't a synonym for dishonesty. It's an equivocal term, which may be, as here, no more than a pejorative epithet. Recklessness in the sense of ignoring a known risk may be evidence pointing towards dishonesty, but that would require SIB to advance a case, not that HSBC should have spotted red flags and failed to, which is the case that SIB is in fact advancing, but that HSBC actually did spot red flags, recognised a sign that SIB's business was being run fraudulently, and then decided to deliberately ignore those concerns because it preferred to carry on earning income from the accounts. And that, my lords, is why Mr. Justice Nugee was right to say that in this case, recklessness collapses into blind eye knowledge. My lord, SIB's skeleton argument tries to rework the language of the pleading by characterising the case, and you have this, if we could go back to paragraph 32 on page 24, looking at the last few lines of that paragraph, my lords, SIB characterises the case there in these terms: a culture of recklessness or a conscious and indifferent abandonment of HSBC's obligations, which can only sensibly be seen as blind eye dishonesty. My lord, that's simply not pleaded. And in any event, it begs the very same questions the judge posed and answered. If it were pleaded that there had been a conscious and indifferent abandonment of HSBC's obligations, one would first of all have to identify the consciousness concerned, and then one would have to ask the question, why? Conscious of what? Indifferent to what? Unless you're saying any of them had a targeted suspicion about SIB which they deliberately ignored, this too cannot amount to dishonesty, even if it were present on the pleadings. Now, the second route that SIB tries is aggregation, and I wasn't going to go over the ground on that we've set out at paragraphs 51 to 56 of our skeleton, Core Tab 5, pages 63 to 65, also in the context of Ground 2, paragraphs 74 to 80, at 70 to 71, because SIB accepts the law as it stands, is as I've described. On that basis, aggregation is patently hopeless, and without aggregation, SIB can't say that HSBC has the requisite body of knowledge to be dishonest. My lords, the supposed policy argument in favour of adopting an approach of aggregation here does not hold up. The fact is that in a proper case where you can identify an individual with a dishonest state of mind, a claim in dishonest assistance is available. In a case where you can make out a breach of a Quince care duty, a claim for breach of the Quince care duty is available. It will be an unusual case where the point that we're concerned with about discharge of a debt occurs. As one's seen from the survey of Commonwealth cases, there was only one other where such a point was even taken. My lords, the third, of course, element that's relevant to policy is the system of regulation which guards the public against the risk of fraud in this area. There isn't a policy gap that would justify the court in tearing up the law around aggregation on the grounds that this is such a novel case, it requires a wholly different approach to attribution. My lords, the third route, blind eye knowledge, SIB appear to suggest at paragraph 54 of their dishonesty skeleton, the reference, I don't think we need turn it up, tab 3, page 34, that because Group 7 was concerned with the state of mind of an individual, it's somehow irrelevant when one comes to SIB's case. Your lordships have well on board the point that Group 7 related not just to the two individual fraudsters, but also the LLP in which the accountant was a member and the bank who employed the other protagonist. And you have my point about the fact that dishonest assistance claims have been brought against corporations, Harris and Daiwa, and in Bilter and RBS, without anyone suggesting that the appropriate approach was somehow radically different and could bypass the need to find a dishonest individual. And the reason for that, my lord, is that the law in this area is settled, and settled at the highest level. Manifest shipping, which of course is a decision of the House of Lords, was a claim again against a corporate entity, approached in the entirely orthodox way we say such claims have to be approached. In other words, identify a guilty mind if you can and attribute that to the corporation. My lords, it's not at all unusual for companies to have policies designed to ensure dissemination of knowledge to those with relevant functions. That doesn't change the required approach to blind eye knowledge, and it didn't change the required approach in Singularis and Daiwa, where those systems were so manifestly defective in the eyes of Mrs. Justice Rose. My lords, blind eye knowledge, again, is a circular argument here, because SIB relies on blind eye knowledge to attribute to HSBC the knowledge it alleges would have given rise to a suspicion, but holding a suspicion is what's required before you can impute blind eye knowledge. So again, an entirely circular argument. My lords, I've covered by those submissions what we have to say about ground 2, And also the overarching point we make about both grounds, that there was no viable dishonest assistance claim on the face of the pleadings, and that was therefore a justifiable basis for distinguishing SOFA. But let me end by going to SOFA, just to tell your lordships what we have to say about that case, because there are some points to sweep up on it. So if we go to the authorities bundle, SOFA is at tab 37, and we need, we need the first paragraph to start with. My lords, what we say by way of overview is that in SOFA, crucially, what the claimant had managed to do was plead what the court held to be adequate particulars of dishonesty as against the corporate trustee, containing all the necessary elements. But let's just look at paragraph 1 to see what the nature of the claim was. It was a claim for breach of trust, where to get past an exoneration clause, it was necessary to plead a case of dishonesty, and the question was whether the claimant had put forward an adequate pleading in dishonesty to survive a strikeout. And I know, of course, that my Lord Justice Arnold will be entirely familiar with this, but the rest of your lordships may have not had occasion to look at the case in any detail. So could we go forward to paragraph 26, and that's page 138. So, my lords, there was an analysis conducted of the particulars of claim to see what one could extract from them against the backdrop of that cause of action. And one finds here at paragraph 26, key passages in the draft amended particulars of claim. First, paragraph 26, that the various sums that were in issue as being dishonest breaches of trust were recorded in the accounts of the trust as being loans. And then at 27, in truth and in fact, the said sums were not loans, but were gifts or purported advances of the said sum to Mr. SOFA. The defendant had no power to make gifts, so it had acted in breach of trust. And then 29, amongst the things alleged there at subparagraph 2, that the defendant had advanced the money to SOFA with the intention he should not have to repay the same. So in other words, intending it to be a loan, which was something that was in breach of trust. And at 6, that the defendant was recklessly indifferent to the requirement that the defendant lend and not advance the money to Hyman SOFA, alternatively advanced it by way of advance and not loan, knowing the money was being provided in that way in contrary to the terms of the trust, and in the premises in personal, conscious and fraudulent bad faith by the trustee charged to be so liable. So that's reckless indifference in the sense of knowing there's a risk in terms of somebody else's rights because you know what your powers are as trustee, and bashing on regardless with a loan. And as one sees, further particulars were given of dishonesty, paragraph 30 over the page. The claimant avers that the personal, conscious and fraudulent bad faith, alternatively dishonesty of the defendant may be inferred from the following matters. And amongst other things, one then has reference to the fact that the defendant, corporate trustee, was a party to the deeds, that it was a professional trustee, and it's to be inferred that it was aware of its duties and the restrictions upon its powers. And at subparagraph 5, they never made inquiry of Hyman as to the reason payment was required. At 7, they never made inquiry as to the ability of him to repay the loans. At 8, that it was to be inferred from the pattern of request and payment that the payments were made as gifts and not loans, and the defendant didn't consider the ambit of or restrictions on their powers and duties. At 9, that Mr. Hyman was suffering from dementia and capable of making a valid request for a loan, and they would have been aware of his mental condition from their communications with him. At 12, the sums paid were recorded in the accounts as loans, and it was to be inferred from the fact that they were actually gifts but were wrongly recorded as loans that the defendant was aware that it was acting in breach of trust and sought to hide the same. And then 13, the defendant released Hyman from his purported obligation to repay the loans on death. There was in fact no release because there were no loans, and this was evidence indicating there were no loans and evidence that the defendant's actions were dishonest.
But you skipped over quite an important subparagraph, which is 9, where it was pleaded the total amount advanced was 57.5 million out of a total of 78 million in the trust. So the large bulk of the totality of the assets of the trust were paid out in this way.
My lord, I'm very grateful for that. I had indeed failed to see quite how grave the situation was. I was focusing on the allegations about knowledge, but absolutely one can see that that fact too would be something, with all the other particulars, that would justify the inference that this is a dishonest behaviour, and indeed it's pleaded as being exactly such. So, my lords, what we say is that, as one sees at paragraph 27, although it wasn't a well-drafted statement of case, what mattered was whether, as a matter of substance, it pleaded sufficient particulars to disclose a case of dishonesty. What one sees at 30 was that it was being submitted on behalf of the claimant. The judge was wrong to hold it was mandatory to identify at the outset the individuals they alleged to have had the relevant knowledge at the relevant time, and it was permissible to provide that subsequently and following disclosure. And then one has the paragraph to which your lordships have already been referred at 32. Now that was against a backdrop where we say the necessary elements, as one sees from that survey of the pleading, had in fact been pleaded as against the body corporate. And the question was whether at the outset one needed to identify the who of it. And the conclusion here was not at the outset, but equally it's perfectly clear that this was a stay of execution, as it were, because if one remained unable to plead that, then sooner or later you would find yourself faced with a strikeout application. And of course, the striking difference between SOFA and our facts is that it expressly asserted at the moment that SIB does not allege such a state of mind against any individual. It's expressly put on the basis of the aggregation of knowledge by the various routes that I've outlined to your lordships. Now that is simply bad in law. So there's no question of a stay of execution. On the face of the pleadings, unlike the position in SOFA, the ingredients aren't there. In SOFA, the problem was a purely evidential problem of which individual you said actually had the state of mind in question, but you were asserting against the entity that it did have the requisite state of mind. On our pleading, the assertions made against the entity do not amount to an assertion that the entity had the required state of mind as a matter of law. So we say that SIB's pleading is doubly bad. It would be bad as against an individual, and the basis on which SIB seeks to attribute knowledge to HSBC is legally flawed and wholly unsustainable. And that answers SIB's submissions at paragraphs 47 and 48 of their dishonesty skeleton, tab 3, page 28. My lord, just finally on the subject of Dalal, which SIB refer to at paragraph 49.1 of their skeleton. The reference is tab 5, page 49, but I wasn't proposing to turn it up unless your lordships would find that helpful. And the authority itself is tab 25, but I can simply summarise in order to round off. Dalal was not a dishonesty case. It was a claim to reverse dispositions made within 6 years of death, where it was alleged that the deceased had the intention of defeating the claimant's claim for financial support, and that was what needed to be alleged for the cause of action. The issue before the court in Dalal was not whether the pleaded claim was bad in law, but whether there was a realistic prospect of success in making the pleaded allegation good. And it scraped through the eye of that needle on the evidence before the court. So that case is simply not relevant to the problem this court has to address, which is whether Mr. Justice Nugee was right to find SIB's pleaded case to be bad in law. We say he clearly was, There is no better case waiting in the sidelines to be pleaded, because generalised recklessness against higher-ups who had nothing to do with SIB at any point and no suspicions about SIB would certainly not get you there in terms of a pleading of dishonesty. But in any event, that is nowhere to be found in these pleadings. And my lord, it is then not appropriate in our submission, and Mr. Justice Nugee rightly concluded that it was not appropriate to leave a pleading in dishonesty, which is bad in law, on the face of the pleadings, simply because there is a rump point on the Quinscare claim that will need to go to trial. A corporation should not find itself having to go to trial to defend a case on dishonesty that is plainly bad in law, because if SIB were to prove what it offers to prove, there would be no dishonesty. So, my lords, those are our submissions in relation to the dishonesty element of the appeal. And, my lords, as I said in opening, the parties are now some 7 months from trial. Witness statements are due in some 2 or 3 weeks. Expert reports from 2 sets of experts per party are due to be exchanged in around mid-May, addressing some 21 expert issues. One certainly doesn't ask the Court of Appeal when they're going to hand in their homework, but I'm sure the court will fully appreciate that an answer to the questions posed to your lordships is going to be of great practical value to these parties if it spares both parties any part of the very substantial expense that lies ahead.
And a response would be appreciated, is that the point?
I was trying to sort of, yes, circumlocute around that, but yes, an early response would, I think, be appreciated in those circumstances, and we will then know what the case is that we are supposed to be addressing at trial.
Well, we're not getting a response this afternoon.
No, I didn't think I would be, my lord. My lord, that, unless there's anything I can assist with, but I think I've already gone round the houses several times.
Thank you very much. Lord Justice Moylan, Lord Justice Arnold, Mr. Fenning.
My lord, as Miss Robertson correctly says, we're well on the way to trial. Witness statements are due imminently. And it's our position that this trial should be allowed to proceed on all the bases which are pleaded. There are a few points which I need to make. My learned friend has, as she says, travelled around the houses several times, and I think I can put my arguments in relation to it fairly shortly. Her reliance on Armstrong and Strang and Z and Z, going back to one of Lord Denning's pithier judgments, is nothing to the point, because it's a case
We don't
about...
actually think it was Lord Denning, in fact. I think it was Lord Justice Evely, but may not matter.
Ah.
That may help Miss Armstrong.
Yeah. Yes, it may well help Miss Robertson. It's all about mens rea, and it's all about deceit. And this isn't a case about mens rea, and it's not a case about deceit. Mr. Justice Snowden in Bilter, interesting, because of course there, the fault of the senior trader, the line manager, was not to stop what had happened. That's an illustration of how conduct up the line can be highly relevant. It's conduct up the line which is relevant here. My learned friend has dissected, I felt almost embarrassed, if I'm young enough still to feel embarrassed, about the criticisms of the pleading as they're taken apart with a forensic knitting needle. But one has to look at pleadings as a whole. One has to look at them, if I may say so, for what they're intended to say and do say, not severing little words and having a crack at them. Ms. Robertson's rightly keen on...
Mr. Fenning, that's a good forensic flourish, if I may say so, where deprecate the reference to the knitting needle, but the point she made was one that at least I took seriously, and I think I need an answer to, which is that you have shunned the case that you put to us this morning so eloquently in your reply. And you have basically said that this is not a case about higher-ups who created a regime which was the corporate knowledge, was aggregated knowledge. It's a case about what happened in relation to SIB. And that can only be the people who had knowledge about SIB.
Lord, no, with respect, I'm going to take you to page 397 to make that good. HSBC is an enormous organisation. We did not need to and do not criticise the overall global policies of HSBC. What we say at page 397 in paragraph 89 2, which is the high point of their comment, is that it's a comment is based on a mischaracterization of the case. We don't allege HSBC operated procedures not caring whether or not fraud was identified. The allegation is their failure to institute and or apply proper policies, systems and procedures was one element of their recklessness. What we're talking about here is not a single failure because of a single fault. It is a whole series of failures, all of which indicate a recklessness as to the proper management of the business, and overall and taken collectively in the way that the authority encourages to do by Lord Hughes. One sees that when you look at the way they fail to institute or apply proper policies, systems and procedures, which we do plead against them, that was an element of their recklessness. That failure, the other failures, collectively amounted to a dishonest and reckless approach to whether or not fraud was detected at a lower level. And it's the actions and inactions at those levels, which means that a learned friend is able to say, although I can point to errors and defects at the granular level of those on the ground dealing with SIB, nevertheless, I can't make a plea in fraud because I can't identify an individual. The reason I can't identify an individual at the moment at that level is because I don't have sufficient information about the institution and application of policies, systems and procedures. What I can say is when you look at those systems, we've looked at them in great detail in our pleading, we don't abandon them. We don't say they were absolutely fine. We say internally, there were no proper policies, systems or procedures. They were not properly implemented. There was an ingrained culture of allowing such procedures as they were not to be properly implemented. So when we go through that range of things which were meant to happen, a proper system of KYC, people monitoring it to make sure it was done, proper systems for aggregating in the sense of bringing together in one place so they could be looked at by those charged with the relationship, all the material known to the bank about a particular customer. All those were failures which, taken together, when you assemble those facts, are because collectively the individuals who between them allowed those cultures and those procedures to be implemented in that way acted in a way which objectively an honest person would not. And I can't find an individual, I can't work out at the moment. It was the person in charge of, you don't even know, for example, if it's the person in charge of Panama, the person in charge of London, or the person in charge of Antigua. We do know that the systems which were in place were inadequate, and they were nobody who was seriously intending to operate a bank in accordance with its obligations would allow those procedures to be conducted in the way they were, would allow those failures to develop. And yet they were allowed to develop. Now, there is a distinction in two aspects between this and your normal case. In your normal case, you may have people who are negligent, very negligent. You may have several acts of negligence. Here we have a total culture over a period of years of disinterest in the bank's obligations to its customers and its regulatory obligations. That cannot be...
Can I just ask you this question, Mr. Fenwick? When you talk about a total culture and a recklessness of the proper management of the business, this seems to have very little to do with SIB. This seems to be a sweeping allegation against the entire conduct of the HSB business with regards to all its customers.
No, it's in relation, as we make clear, to its relationships with correspondent banks. We make absolutely clear that it's the way in which correspondent banks were neglected. Due diligence on those banks was allowed to fall behind. There was no effort to understand them. There was no effort to understand the risks which correspondent banking imposed. And just standing back.
So that's an allegation of negligence with respect to its relationship with correspondent banks. All of it. It, of course, begins with negligence, but when it is so serious and so ingrained, one is entitled to say, and I will say at trial, that those who allowed this to happen must have been aware that doing this would not enable them to identify fraud at the level of SIB, and yet allowed it to continue recklessly, neither knowing nor caring whether their systems would provide adequate protection. And that, in my submission, is an adequate plea at this stage. Lord, the second point I wanted to make in relation to Miss Robertson's argument about claims against corporations. If this is a claim against a corporation, it is all done by personal liability, personal dishonesty of an individual. I accept that in the normal case, there will be an individual, because in the normal case, one is only dealing with a very limited series of facts. What is astonishing about this case, and those dealing with due diligence in relation to Madoff may have had a similar problem. Here, you have so many incidents, so many failures over such a long period of time that it can't be dismissed as negligence inadvertence. Looked at properly, one has to say this bank did not care what happened with these correspondent relationships so long as they were getting paid for it. And that's what we allege. And in my submission, when you have it over a period of years, you can't identify, because you're being cautious, you haven't got the evidence on disclosure, you can't identify an individual person who had a light bulb moment where they realized something which an honest person would have stopped. You can't be deprived of the overall plea of dishonesty against the corporation because of the way in which they've conducted their affairs. So it is different, it is new, and it is something which properly deserves to be considered in a full trial. Now, just to deal with the point which my learned friend made, in the correspondence where we were harried and harassed with letters about what we meant, in that letter we did make plain that we were
allegations of an ingrained culture of failing to obtain or institute proper policies at page 358 of the supplemental bundle. Well, I'm looking. It's amazing how the electronic type gets held up somewhere between London and Suffolk. But I'm hoping it will arrive so that I can unscramble the note and read it. I may have to use a different machine to enable me to do so. If you'll just bear with me. Yes, as I've said, HSBC is a vast organisation. It covers a wide range of relationships and banking services. Of course, we're not alleging their management of relationships across the entire spectrum is reckless. We don't have the evidence, and we don't need to go that far. We focus on the systems and processes which were applicable and relevant to SIB. Those failings may well involve senior bankers, as well as the more junior employees managing the account. Just because we focus on what's relevant to SIB doesn't preclude the involvement of the board in those matters. And so far as suspicion is concerned, HSBC clearly recognised relevant risks applicable to SIB. Their compliance policies makes clear they recognize risks. They subscribe to the Wolfsburg principles, as we say in paragraph 153 of the particulars of claim. The risks they recognized including jurisdictions with lax anti-money laundering, banking secrecy or confidentiality rules, offshore activities, build-up of large balances inconsistent with the customer's known business, unusual large business offers, correspondent banking services. That shows that HSB as an entity was fully aware of the relevant risks applicable to HSBC. One would have expected the individual bankers to do so too. But those risks were ignored. They were ignored and never reflected in due diligence. And that was an endemic failure rather than the failure of any one individual. We say that this wasn't just a negligent failure of systems, but systems in place which simply meant that there was nobody who was charged with the obligation so that they could either comply with it or not comply with it. And that's a failure which HSBC must have known about, and which we can probably characterize as reckless. And it's all very well, many friends say, well, recklessness. Recklessness is evidence of dishonesty. It's a badge of dishonesty. It's used in this case in the sense of dishonesty, in the sense that who didn't implement those policies, neither knew nor cared what the result would be. And the fact that I cannot now identify those, I may be able to, when I get the witness statements in 2 weeks' time, I may be able to, when I get proper disclosure. If I can, I shall plead them. But if I can't, I'll be saying to the judge at trial, when you look at the way in which this bank conducted its business in relation to its customer SIB, with all the knowledge that it had, as a bank, one can properly say that objectively the bank gave dishonest assistance to Mr. Stanford and allowed his fraud to continue yet longer. My Lord, I think I've covered everything that I needed to, unless there's anything else on which you'd like my assistance.
No, thank you, Mr. Fenwick. Lord Justice Moylan. Lord Justice Arnold.
No, thank you.
Very good. Well, that concludes the argument in very good time. Thank you. Thank you both. Thank you to your juniors and solicitors for a very well-prepared case. We will take time to consider judgments, and we will hand them down in the usual way as quickly as we may, but I fear prior to Easter is optimistic, I'm afraid, Miss Robertson. And but we'll do our best. And when you get them, will you please agree the order that results from them and costs? And if you're not able to do so, we will deal with those matters in writing.
I'm obliged.
Well, I'm grateful. We had a little homework in looking across the world at cases involving corporate knowledge. If you could give us a date by which you would like to have them, we will make sure that we meet that date.
Friday night would be very helpful, Mr. Fennick.
Friday night it shall be, my lord.
Thank you very much. And as I say, thank you to all the lawyers.
Pardon, my lord, for cutting across, but if Mr. Fennick's going to only identify what it is he might rely upon from the trawl across the world on Friday, might your lordship set a date by which we have to respond to that,
well,
if we have anything to say?
Yes, I suspect you won't, because I think the trawl that I invited him to make was perhaps at a too early a stage in the argument. But I mean, it was a narrow inquiry as to whether this argument that he's adopted in relation to large corporations and fraud alleged against large corporations had been dealt with elsewhere in the Commonwealth universe. I suspect the answer actually is no, that this argument has not been put that way before. But if he comes up with anything, you obviously can reply to it. And I would say perhaps Monday night for that.
I'm obliged, my
Lord, I will, so far as possible, ensure that we simply provide the material and a neutral digest on it, as opposed to trying to reopen the argument and have another part.
Thank you very much, Mr. Craig. Very good. Thank you.